Governor Haslam, I've already provided information to you this morning. When I took a break from moving, I'm taking another break. But I provided information to you earlier about John Perry and the child molestation, and also about Warwick Robinson and Covenant Presbyterian Church and their use of Metro Police to conceal the known molester. And also that John Perry and Mike Huckabee co-wrote 2 books together, which were published in 2007, 2008, as Governor Huckabee ran for President of the United States and is now running again in 2016. But in honor of Miss Harper Lee, who's in this picture here with these children back in 1961-62, somewhere in that time, as I was in first grade. In honor of her, I'm releasing some information about the Vanderbilt rape trial, which is a mistrial, I guess now. I'm not sure what happens to Chris Boyd, who's been convicted of a sex crime cover-up, or what happens to myself, since I've been convicted and have a suspended sentence for contempt of court. But in honor of Ms. Lee and what she tried to teach all of the children in the United States and across the world, she's got a new book being published and released on July 14, 2015, called Go Set a Watchman. And so, as someone who's been somewhat of a watchman myself, I am doing this in honor of her new book coming out.
I think I'll have to reiterate what I said the last time Mr. Austin Davis was here. If you are recording these proceedings, do not record them. Do you understand that? Mr. Davis? Yes. Which one is Mr. Davis? You're Mr. Davis?
Yeah, yes, sir.
Okay, who recorded the proceedings the last time? Well, let me do it this way. Raise your right hand.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I did.
All right, step up to the podium. Now, the last time you were here, I specifically told you not to record the proceedings. Someone recorded them, sent them out to the Tennessean and other people as well. I have received a copy of it. I have listened to it. Did you record it or have someone record those proceedings? Are you going to answer?
Yeah, I have to answer that.
I asked you a question, yes.
Well, constitutionally, I have to answer the question.
Are you taking the Fifth Amendment?
Yes.
Okay. All right. Now, you are here because those proceedings were recorded against my specific instruction, which I have the authority to do, particularly under Rule 30, where I have the discretion to determine whether a person can record proceedings in this court. And I specifically told you not to record. By your silence, you are saying to me that you probably did, but I'm not going to take that as an admission. But that's why you're here today. And Mr. Cade, do you have anything that you want to present to the court?
Your Honor, I would just say that the orders that were down, I presented appropriate law in my response brief.
The order that I submitted was a correct order. It came directly from me. It did not have to have the same things that you pointed out in your response. My order was appropriate. But go ahead.
I'm not saying it wasn't appropriate. I'm just saying it wouldn't be legally effective. That's my argument.
How is it not legally effective?
It didn't meet the requirements under the Tennessee Rules of Civil Procedure 58.
Well, this is a criminal court. This is not a civil court.
The matter is a matter of civil rights, and that's why I thought the Civil Rules of Civil Procedure apply. They are adopted by the Supreme Court.
All right.
And in addition, there are two under Tennessee Supreme Court Rule 30 also allows recordings to be held in open court. And so we weren't
not
sure.
only in the judge's discretion, and I specifically told him not to record these proceedings. Now, how is it that the rule allows you to record something when I tell you not to record recording. I'm not talking about you, I'm talking about your client.
Well, this all began inside the case involving Brandon Van.
I understand that. The
And because
issue here today is why did he record the proceedings and publish the proceedings?
I think that goes back to what he's invoking under the Fifth Amendment, that he's not going to say that he did or didn't. He's not making an admission that he did record the proceedings.
That's the only issue we have here today, whether he should be held in contempt for recording the proceedings in this courtroom and publishing those proceedings. I specifically said that he couldn't do it, and that we have an official court reporter that takes the proceedings in this court, as in all other courts for that matter, and you should follow the instructions of the court. He didn't do that. Tell me why he should not be held in contempt.
Well, it goes back to the fact that this was a derivative of an open proceeding where there was recording and mass media that was involved. And so he was originally, from our perspective, a First Amendment violation occurred on January the 14th during the middle proceeding when he was escorted out without a hearing, which under the law is required, okay? And from that moment on, as a matter of law, that the hearing involving Brandon Vandenberg and Corey Beatty would have been closed. And if that's the case, under Supreme Court Rule 30,
under the law, I can exclude him from proceedings, particularly if those proceedings are being broadcast, because there is an alternative. The alternative was for him to watch the proceedings on television like anyone else. So he was not excluded because he could view the proceedings on television. And the rule allows that. An alternative. The alternative was that the proceedings were televised and he could watch them.
The United States Supreme Court's previously taken up this issue back in the 1940s in relation to listening to similar open proceedings on the radio and other, obviously television may not have been available at that time, but we think it applies in this set of circumstances where even the U.S. Supreme Court wouldn't agree that any proceedings on the internet and television would apply with regards to the closure of the opening of proceedings. In other words, that's not a reasonable alternative of the law. And I've stated that in my brief.
Go ahead.
And so based on that, based on the fact that under Tennessee law, it at least says you have to have a hearing before you're excluded, and that any order that comes out of there needs to be in writing. And given the fact that under the U.S. Supreme Court law, that the television is not a reasonable alternative, and neither is the radio, neither is the print media, whether on the issue of closure or whether it's an opening proceeding, then we think there is a violation of the First Amendment. And if the court essentially, as of January the 14th, was saying that the proceeding was closed, then what we're saying is that everything that occurred thereafter, particularly involving the mass media, should have been closed to the public in general. Therefore, because that's grounds for a mistrial under the proceeding. It should have been an open trial or closed early in the game. And if the court was going to close it during the middle of the proceeding, it should have closed it to everybody.
Well,
that's what the law is going to say.
That argument doesn't hold water anywhere. Okay, let me move on. Mr. Austin Davis also filed an affidavit with the court saying that he has never engaged in any offensive conduct with a public servant court officer of Judge Monty Watkins' court. I have never engaged in any offensive conduct with a public servant court secretary of Judge Monty Watkins' court. I pointed out the last time that I had reliable information that Mr. Austin Davis called my office, recorded his conversation with my secretary, and published that on the internet. And I said not illegal, but it is offensive to do something without her knowledge or permission. I consider it offensive to do that.
As a citizen, I don't.
Well,
As a
you know
public
what?
citizen, I don't.
Well,
Why is it offensive?
Your opinion does not count with regard to how I view something, all right? You are probably...
I understand that.
Today, and I'm going to tell you again, if I didn't say it earlier, do not record these proceedings. Do you understand me? Do you understand me?
I'm not recording these proceedings.
Are you having someone record these proceedings?
No.
All right, if I hear it on the internet, I'm going to issue another show cause order for you to come in here, if I hear it again. Now, I have heard the recording from the last proceeding, and that I believe that you sent to the Tennessean. Did you not send it to the Tennessean?
I sent it pretty much to a lot of people all over the United States.
All right, you sent it to a lot of people all over the United States.
And it didn't, and I'm not publishing it. Publishing is where you're making money from something.
You don't have to make money to publish something. This is what I'm going to do. I do hope you're in contempt. I'm going to suspend your sentence. I want you to leave my courtroom and leave this court alone. Do you understand? Do you understand?
Yes.
All right.
Pastor.